Afternoon, Sir Declan.
Hi, Cheryl. How are you?
I'm good. How are you?
Fine. I sent you through a copy of the stuff
Yep.
which you can circulate around anybody who actually wants to get a copy. I'm sorry about the slides because I think it would have been much better with the slides, but to be honest, I'm afraid my soul just wasn't up to it
Don't
over the last
worry.
few days.
No, don't worry at all. What we can do is I'll ask my colleague Declan Coyle to circulate your Word document around anyone who's attended today, and then
Yeah.
people can pick up on that as they wish.
Okay. That's grand.
We have a really good attendance list for today, so I'm just waiting for a few more people to filter in.
Okay.
And then we'll make a start. So you've definitely been a popular draw.
Well, I hope I'm not a huge disappointment, but there you go.
I would never doubt that.
or even worse, got the questions I can't answer.
That is the story of my life when I'm teaching.
Yeah. Okay.
Okay, so we'll just give another couple of moments, and then I'll do a brief introduction, 30 seconds on housekeeping, and then hand over to you.
Okay, that's fine.
Perfect. Okay, I think it's time to make a start. Good afternoon, everybody, and welcome to today's Human Rights Centre Seminar Series event. This is the first event in our 2021-2022 academic year, and I look forward to seeing you today, but also welcoming you to future seminar series events. It's great to see such a great diversity of people and wide participation in terms of who has signed up for today's talk. It is my pleasure to welcome Sir Declan Morgan as our first seminar series speaker today. Sir Declan will need no introduction to many of you on this call, but of course to give him his dues, Sir Declan has recently retired after more than a decade as Northern Ireland's most senior judge. And as part of that illustrious career, Sir Declan was called to the bar in 1976, becoming a QC in 1993, a High Court judge in 2004, and the Lord Chief Justice in 2009. Of course, and it would be remiss of me to fail to mention that Sir Declan is also a graduate of Queen's and a former judge in residence in the School of Law. In terms of the format for today's event, I will shortly hand over to Sir Declan to give his presentation. We have a text document of his speech, which I will be able to circulate with you all after today's event. After Sir Declan has finished his remarks, there will be time for question and answer. I should remind you that today's event is being recorded, and we will share that on our social media channels. In terms of housekeeping, given that it is a recorded event, could I ask you all to keep your cameras off and to mute your microphones until we come to the question and answer aspect. So for now, I will hand over to Sir Declan. Thank you.
Thank you very much, Cheryl, for your kind introduction, and it's a great pleasure to be here to join you today. From my past life, I still have one outstanding case which concerns freedom of expression. I'm obviously not going to discuss the case, but I do want to draw attention to two recent decisions of the European Court in this territory and the application of the underlying principles in the leading decision in this jurisdiction. I also want to look briefly at the recent Supreme Court decision in Ziegler dealing with freedom of assembly. But I've approached the session overall on the basis that I'm happy to take questions on any aspect of my previous work as LCJ on which I can provide an answer, and I will therefore leave time for those who wish to ask questions rather than anticipating those things in which people may be interested. I anticipate that I will speak for about 30 minutes or so. I have to start with an apology. I'm afraid as a result of certain debilitation arising from COVID, through which I'm still working through, I really just wasn't able to put together slides, which I think would have made this presentation easier. I hope that those of you who want to look at it will take up Cheryl's offer, and if you find it interesting, to read through the material. Freedom of expression and freedom of assembly engage convention rights under Articles 10 and 11, and the scheme of both articles is to assert the right in the first part of the article and possible grounds for interference in the second part. All of you will be familiar with the form. I certainly don't need to set it out here. The first European court decision I want to look at is Liliendahl against Iceland, which was a decision of the section in May 2020. The background was that an Icelandic municipal council had approved a proposal to strengthen education and counselling in elementary and secondary schools on matters concerning those who identify themselves as lesbian, gay, bisexual or transgender. That was to be done in cooperation with the National LGBT Association in Iceland. The decision was extensively reported in the news and led to substantial public discussion. That included radio stations where listeners could phone in and express their opinions on the decision of the Municipal Council. Can I say that the report is silent on whether Stephen Nolan was actually the radio presenter, but it wouldn't surprise me given all that he does if he was. The applicant was one of those who took part in the public discussion. He criticised the radio station for covering what he called sexual deviation and indoctrinating children on how to become sexual deviants. He expressed his disgust at the content of the radio show. The applicant's comments were investigated by police as a result of numerous complaints. Initially, they were discounted as simply being an aspect of freedom of expression, but were then, on reconsideration, considered to potentially constitute publicly threatening, mocking, defaming, and denigrating a group of persons on the basis of their sexual orientation and gender identity. The district court, before which the case progressed, considered that the comments did not reach the threshold required to justify interference with the applicant's freedom of expression rights, and that the applicant had not intended to violate the relevant statutory provision. That decision was overturned by the Icelandic Supreme Court. That court found that the requirement of intent was satisfied by the intentional use of the words by the applicant, and that account should not have been taken of the motives which the applicant claimed were behind his expression. The applicant, disappointed, then brought his case to the European Court of Human Rights, and the European Court first considered the application of Article 17 of the Convention. That is not, of course, one of the Convention rights brought home by the Human Rights Act, but it says that nothing in the Convention may be interpreted as implying for any state, group or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein, and that the limitation to a greater extent than is provided for in the Convention. The court explained that the decisive point under Article 17 is whether the applicant's statement sought to stir up hatred or violence, and whether by making them he attempted to rely on the Convention to engage in an activity or perform acts aimed at the destruction of the rights and freedoms laid down in it. If applicable, Article 17's effect is to negate the exercise of the Convention right that the applicant seeks to vindicate in the proceedings before the court. Article 17 is only applicable on an exceptional basis and in extreme cases. And in cases concerning Article 10 of the Convention, the court considered that it should only be resorted to if it is immediately clear that the impugned statement sought to deflect this article from its real purpose by employing the right to freedom of expression for ends clearly contrary to the values of the Convention. The court concluded that the circumstances of this case did not reach the high threshold for the applicability of Article 17. The court accepted, however, that the comments were highly prejudicial, but that it was not immediately clear that they were aimed at inciting violence and hatred or destroying the rights and freedoms protected by the Convention. Article 17, as I've said, is not, of course, one of the Convention rights brought home by the 1998 Act, but the jurisprudence is obviously helpful in dealing with the approach to Article 10. Having rejected the applicability of Article 17, the court then began the conventional Article 10 exercise, noting that freedom of expression constituted one of the essential foundations of a democratic society and one of the basic conditions for its progress. That included ideas that might offend, shock, or disturb. Such were the demands of pluralism, tolerance, and broad-mindedness, without which there was no democratic society. Any interference had to be construed strictly, and the need for restrictions had to be established convincingly, and I'll come back to that. The court explained that states had a margin of appreciation, which meant that where the independent and impartial domestic courts have carefully examined the facts, applying the relevant human rights standards consistently with the Convention and its case law, and adequately balanced the applicant's personal interests against the more general public interest in the case, it was not for the court to substitute its own assessment of the merits unless there were strong reasons for doing so. And this approach, I've noted, has also been particularly noticeable in deportation cases, particularly in relation to the deportation of minors. The court then went on to look at the concept of hate speech. The first category is the gravest form of hate speech, which falls under Article 17 and is therefore excluded entirely from the protection of Article 10. The second category is comprised of less grave forms of hate speech, which the court has not considered to fall entirely outside the protection of Article 10, but which it is considered permissible for the contracting states to restrict. Into this category, the court has not only put speech which explicitly calls for violence or other criminal acts, but has held that attacks on persons committed by insulting, holding up to ridicule, or slandering specific groups of the population can be sufficient to allow the authorities to combat prejudicial speech within the context of permitted restrictions on freedom of expression. In hate speech cases which did not call for violence or other criminal acts, the conclusion has been based on an assessment of the content of the expression and the manner of its delivery. That would tend to support the proposition that the test is objective and the motives of the speaker in such cases will not prove exculpatory. I should say, although I'm not going to deal with it, that issue arose in the decision of District Judge McNally in the Pastor McConnell case. And in fact, in that case, because the issue concerned the pastor's entitlement to protection for his religious rights, that to some extent his motives were in fact taken into consideration by the trial judge. I think that is a legitimate and was a legitimate approach in that case. The second European case is Baldassi v France, decision in June 2020. The applicants were members of a local collective supporting the Palestinian cause as part of an international campaign entitled Boycott, Disinvestment and Sanctions. They were prosecuted for calling on customers at a hypermarket not to purchase products from Israel. The relevant law prohibited incitement to discrimination against a group of persons on account of their origin or belonging to a specific nation. The court accepted that the convictions had been intended to protect the right of market access by producers or suppliers of products from Israel. The convictions had therefore been a means of protecting the rights of others, which was a legitimate aim. The court recognised that a call for a boycott constituted a very specific mode of exercise of freedom of expression, and that it combines expression of the protesting opinion with incitement to differential treatment and may amount to a call to discriminate against others. Incitement to discrimination is a form of incitement to intolerance, which, together with incitement to violence and hatred, is one of the limits which should never be overstepped in exercising freedom of expression. The court distinguished this case from its earlier decision in Willem v. France. In that case, the applicant, as mayor, had instructed the municipal catering services to boycott Israeli products. He made the announcement without prior debate or any vote in the municipal council, and accordingly had not encouraged free discussion of this subject of public interest. Essentially, he had abused his powers and interference was justified. And the interesting thing about that case is that it's one of the examples where speech by politicians has not been given the enhanced protection that political speech normally achieves. In this case, the applicants were ordinary citizens, and their influence over consumers was not comparable to that of a mayor over his municipal services. The purpose of the call for the boycott had been to trigger or stimulate debate among supermarket customers. There had been no racist or anti-Semitic remarks or incitement to hatred or violence. The convictions of the applicants proceeded simply on the basis that they had called for a boycott of products from a particular geographical location. There had been no examination of whether that interference was necessary in a democratic society to attain the legitimate aim pursued. The court had been required to give detailed reasons for its decision. The actions and remarks imputed to the applicants concerned a subject of public interest and contemporary debate. The actions and remarks in question had fallen within the ambit of political or militant expression. It was in the nature of political speech to be controversial and often virulent. That did not diminish its public interest, provided it did not cross the line and turn into a call for violence, hatred, or intolerance. That was the limit that should not be overstepped. The applicant's convictions had not been based on relevant grounds sufficient to show that the domestic court had applied the principles set out in Article 10. And essentially what had happened was that the court looked at the statute which says differentiation on the basis of belonging to a specific nation means the offence has been committed, and they did not go on to analyse or balance the competing arguments from the applicant's point of view. The leading domestic case in this area is the decision of Maguire J, as he was in Jolene Bunting's application. The applicant was a Belfast City Councillor. The case arose as a result of complaints made to the Local Government Commissioner for Standards. The complaints related to various remarks made by the applicant and her approbation of remarks made by others about Muslims. The acting commissioner considered the complaints and concluded that a suspension for a period of 4 months from council business was appropriate while the matters were being investigated. The applicant appealed to the court. In a careful and instructive judgment reviewing the terms of the code, the approach that should be taken by the court to the decision of the acting commissioner, and the extent of the assistance that the applicant could derive from Article 10 of the Convention, Maguire J concluded that the decision to suspend for a period of 4 months was proportionate. He paid particular attention to the question of whether the matter which is the subject of the complaint constituted political speech. He concluded that a generous interpretation should be taken to that concept. He also recognised that not every pronouncement by a politician should attract that protection, and the test will usually depend upon whether the matter complained of had a sufficient connection with a matter of public interest or debate. There is a great deal more in that decision, but time does not allow me to explore it further. I do, however, strongly recommend it to all looking at this area. Having had the benefit of these decisions, I consider that the following propositions can be extracted. 1. Freedom of expression is a fundamental right in a democratic society. 2. It follows that any restriction on the exercise of the right under Article 10.2 must be strictly construed. 3. If the exercise of the right is to be restricted, it is invariably where the speech promotes violence or hatred or intolerance of the democratic values of the Convention. 4. Political speech qualifies for enhanced protection. 5. In order to qualify as political speech, it is not necessary that the speaker holds a political office, nor does it follow that because the speaker holds a political office, that the speech attracts the protection. It is for the court in each case to assess whether or not the speech is on a matter of public interest or debate. 6. Cases such as Willem v. France and Ferret v. Belgium demonstrate that politicians who abuse their position in order to stifle public debate or to promote their personal prejudices will lose the enhanced protection. 7. The European Court acknowledges that each state has a margin of appreciation in respect of the restriction of the right to freedom of expression subject to European supervision. 8. That means that the court will review the intensity of the analysis of the nature of the speech and the corresponding strength of the ground upon which a restriction is imposed. A good demonstration of the type of analysis required is that exercised by Maguire LJ in Bunting's application, where he analysed each of the complaints and identified those which he found justified the interference and rejected some of the matters upon which the acting commissioner had placed reliance. 9. The analysis is central to the ability of the court to adequately explain the justification for any restriction. Where that analysis has not been carried out, the European Court is likely to find a violation. Baldassi is an example of that. 10. Where the analysis and reasons for the restriction are explained, bearing in mind the appropriate European case law, the court will not normally interfere with the proportionality assessment made by the domestic court. And lastly, proportionality also plays a role in the extent and nature of any interference with the right. That brings me to the case of DPP v. Ziegler, decided by the Supreme Court in June 2021. The case arose from a protest at the 2017 biennial Defence and Security International Arms Fair. The action taken consisted of lying down in the middle of one side of the dual carriageway of an approach road leading to the Excel Centre, that is the side for traffic heading into it. The appellants attached themselves to two lock boxes with pipes sticking out from either side, and each appellant inserted one arm into a pipe and locked themselves to a bar centred in the middle of one of the boxes. There was a sizable police presence at the location in anticipation of demonstrations. Police officers approached the appellants almost immediately and went through the 5-stage process to try and persuade them to remove themselves voluntarily from the road. When the appellants failed to respond to the process, they were arrested. It took, however, approximately 90 minutes to remove them from the road. And this was because the boxes were constructed in such a fashion that was intentionally designed to make them hard to disassemble. The protesters were prosecuted for obstruction of the highway without lawful excuse. The critical issue was whether the obstruction was the lawful exercise of the right to assemble. The district judge made the following findings. A. The actions were entirely peaceful. They were the very epitome of a peaceful protest. B. The defendant's actions did not give rise either directly or indirectly to any form of disorder. C. The defendant's behaviour did not involve the commission of any criminal offence beyond the alleged offence of obstruction of the highway, which was the very essence of the defendant's process. There was no disorder, no obstruction of or assault on police officers, and no abuse offered. D. The defendant's actions were carefully targeted and were aimed only at obstructing vehicles headed to the DSEI Arms Fair. He then dealt with the issue of some evidence of other traffic which he found was not convincing. E, the action clearly related to a matter of general concern, namely the legitimacy of the arms fair and whether it involved the marketing and sale of potentially unlawful items, such as those designed for torture or unlawful restraint, or the sale of weaponry to regimes that were then using them against civilian populations. F, the action was limited in duration, and the judge had to deal with the issue of the period that he should take into account, and indicated that he was minded to take into account the period leading up to arrest, but not the period that it took for the police officers to disassemble the items and remove the protesters. The judge indicated that even if it was the latter, that he would still have reached the same decision. And I think it's fairly clear that the superior courts concluded that his approach to that initially was wrong. G, he said that he'd heard no evidence that anyone had actually submitted a complaint about the defendant's action in blocking the road. The police response was entirely on their own initiative. And lastly, although it was a minor issue, he noted the long-standing commitment to opposing the armed trade that all of the defendants had demonstrated. So he held that the interference with the highway was protected by Article 11, and the defendants had a lawful excuse for the interference. The Divisional Court was not impressed. The court criticism of the decision was set out as follows. The district judge said that the defendant's actions were carefully targeted and were aimed only at obstructing vehicles headed to the arms fair. However, the fact is that the ability of other members of the public to go about their lawful business, in particular by passing along the highway to and from the Excel Centre, was completely obstructed. In our view, that is highly relevant in any assessment of proportionality. This is not a case where, as commonly occurs, some part of the highway, which of course includes the pavement, is temporarily obstructed by virtue of the fact that protesters are located there. That is a common feature of life in a modern democratic society. For instance, courts are well used to such protests taking place on the highway outside their own precincts. However, there is a fundamental difference between that situation, where it may be said that a fair balance is being struck between the different rights and interests at stake, and the present cases. In these two cases, the highway was completely obstructed, and some members of the public were completely prevented from doing what they had the lawful right to do, namely use the highway for passage to get to the Excel Centre, and this occurred for a significant period of time. So the Divisional Court overturned the decision of the district judge and directed that the appellant should be convicted. The matter was then referred to the Supreme Court, and there were two certified questions, one in relation to the nature of the appeal, but the certified question with which I'm concerned was whether deliberate physical obstructive conduct by protesters was capable of constituting a lawful excuse for the purposes of Section 137 of the 1980 Act, where the impact of the deliberate obstruction on other highway users is more than de minimis and prevents them, or is capable of preventing them, from passing along the highway. The majority allowed the appeal and restored the decision of the magistrate, and the principal judgment was given jointly by Lords Hamblin and Stevens. At paragraph 72 of their opinion, they adopted certain observations of Lord Neuberger in relation to the Occupy protest, where he indicated that the factors to be taken into account include the extent to which the continuation of the protest would breach domestic law, the importance of the precise location to the protesters, the duration of the protest, the degree to which the protesters occupy the land, and the extent of actual interference the protest causes to the rights of others, including members of the public. Lord Neuberger also identified two further matters. One was whether the views giving rise to the protest relate to very important issues, and whether they are views which many would see as being of considerable breadth, depth and relevance. So that is the public interest point. And secondly, whether the protesters believed in the views they were expressing. And in relation to B, it's difficult to conceive of any situation in which it would be proportionate for protesters to interfere with the rights of others based on views which they did not believe. The point of dispute between the majority and Lords Hodge and Sales concerned the importance of the police conduct. If, it was argued, the police were entitled to arrest and remove the protesters, it could only be because it was reasonably suspected that the offence of obstruction was being committed and there was no lawful continuation for the continuation of the protest. That had not been addressed by the judge. The minority did not agree that the district judge had properly reflected the fact that the dual carriageway leading into the Excel Centre was completely blocked and did not analyse the disruption actually caused and likely to occur. They also considered that the judge had not properly reflected the period of disruption before the protesters could be removed. Just give me a moment, please. The broad circumstances surrounding this case are being played out virtually on a daily basis in many parts of the United Kingdom. It is disturbing to find that there is such a degree of dispute as to the relevant factors to be taken into account and the weighting to be given to the disruption caused by the protest. There is continuing political interest in this issue, and it seems inevitable that the Supreme Court will once again be asked to address the issues in a way which gives clear guidance. As the majority indicated in their review of the principles underlying Article 11, arrest, prosecution, conviction and sentence are all restrictions within both articles. Different considerations may apply to the proportionality of each of those restrictions. The proportionality of arrest, which is typically the police action on the ground, depends on, amongst other matters, the constable's reasonable suspicion. The proportionality assessment at trial before an independent and impartial tribunal depends on the relevant factors being proved beyond reasonable doubt and the court being sure that the interference with rights under Articles 10 and 11 was necessary. The police's perception and the police action are but two of the factors to be considered. It may have looked one way at the time to the police, on which basis their actions could be proportionate, but at trial the facts established may be different, and on that basis the interference involved in a conviction could be disproportionate. I agree, but I also wonder whether the proportionality assessment of police conduct in clearing the highway is different from the assessment that should take place when a decision to prosecute or convict the protester is an issue. Does it necessarily follow that because the police were entitled to clear the highway by arrest and removal, that the protesters should be subject to a further interference by way of criminal charges? Does that not require a different proportionality assessment? And may that not give rise to a different outcome? It seems to be inevitable that the Supreme Court is going to come back to have to deal with this issue, but even more troublingly for my erstwhile colleagues, I suspect that these cases will have to go through the normal appeal process before the Supreme Court gets a chance to clarify. One of the common themes through all of these cases is the extent of difference of analysis and conclusions that have been reached by different courts right through the process, whether in this jurisdiction or in others. That continues to be, in my view, a troubling issue for those who are looking for some certainty as to what the state of the law is and how these matters should be dealt with. What is absolutely clear is that for judges who are dealing with these cases, that an enormously careful analysis of the background and circumstances of the speech and the basis upon which the interference is to be justified is required if there's to be any prospect of the proportionality assessment being upheld. I hope that has been helpful. to anybody who is involved in this territory. And as I indicated at the start, I'm perfectly happy to take any questions that I can answer in relation to my previous work. Thank you.
Thank you very much, Sir Declan. I see we already have a question there. So people, please feel free to either come in using your audio, your video, or if you want to use the chat bar, please feel free to do so. So we have our first question there. We have a hand up from John Wadham. John, if you'd like to come in. Are you able to hear us okay, John? Possibly something has gone wrong there, but we'll return to John in a moment or two if he's able to reconnect with us. Would anyone else like to offer up any remarks or any questions to our guest? There might be a permissions issue.
I just hope, Cheryl, I haven't managed to send them all to sleep in the course of that half-hour talk.
I don't think so. I think we might have had a muting issue. If anyone else wants to come in and try again, that should be us now. Okay.
Hi, it's John Wadham here. Hi. So
Hi, John.
That was very, very interesting. I'm the Human Rights Advisor to the Policing Board in Northern Ireland, so I'm particularly interested in issues of policing and protest. But I'm also reflecting on on what's happening in England at the moment, which is that in relation to the Insulate Now protesters, some people who have been using their cars and have found that the highway has been blocked, have decided to take action by picking the demonstrators up and moving them to the pavement. Now, there's been a little bit of debate on Twitter about how, as an individual, you would make the assessments as to whether assuming, and I don't want this very complicated law, but assuming that you're entitled to remove someone from the highway if they are committing the Section 137 offence. I'm not asking for your advice on that, but assuming that's the case, an individual who wanted to take this action themselves, would they have to go through all of those exercises? In other words, making a decision about whether someone was entitled to protest by blocking the highway before they decided whether or not the person was committing a criminal offence, and therefore before they were able to take their own action. Maybe that's difficult to analyse in a short period, but I'd be interested in whether the individual driver would have to make that assessment in relation to Articles 10 and 11. Thank you.
Thank you very much, John. I don't think I'm going to be much help to you in terms of the reply, but essentially the position is that the protesters may well be physically blocking the highway, but of itself, that does not mean that they're committing any criminal offence. And therefore, you can't assume that the protesters are in fact committing a criminal offence simply by virtue of the fact that they are sitting in the road. So that anyone who, if they are acting lawfully in using their Article 11 or Article 10 rights, then anyone who removes them is liable, I would have thought, to a charge of assault. But so it means that for anyone to interfere in those circumstances, I'm afraid they would, in my view anyway, need to be extremely careful because they may well find themselves in considerable difficulty.
Thank you.
Thanks, John. We have a second question from Chris McCrudden. Chris, if you'd like to come in.
Hi, Chris.
Hi, Sir Declan. Thank you very much for that contribution. That was fascinating. The question I've got is considerably less detailed and considerably less interesting than John Wadham's, but let me try it anyway. One of the features of what you've been saying is the heavy emphasis on proportionality. And I'm wondering what your reaction to the multiplicity of proportionality tests that are going on at the moment, and the extent to which proportionality prevents the kind of clear guidance that you would seem to prefer in this kind of area. In other words, given that proportionality is so context specific and requires such individualized assessment in each particular case, is it really possible to have the kind of overall policy guidance that is going to be particularly helpful to the ordinary constable on the beat? And if that's the case, does that lead you to be more skeptical of whether proportionality is the appropriate way forward in this kind of area? Now, I realize, of course, that we have proportionality, so I'm not, in a sense, it's a rather theoretical question. But if you were starting from scratch, would you use proportionality as the dominant test in this kind of situation?
Interesting question, Chris. I agree that the proportionality assessment in all of these cases needs to be fact specific. I mean, for instance, it seems to me that if you have a case where somebody is blocking a road and inconveniencing people attending an arms fair, that is one thing. If you have people blocking the road and an emergency vehicle comes along and it has no other means of access to its location other than in this way, and the protesters continue to block the road, that is obviously another consideration which is highly relevant to whether or not their conduct is proportionate. So I think it is difficult to get away to some extent from the approach on an individual basis. I mean, to some extent, I just wonder, is this going to end up, in a typical common law fashion where we plod around for a bit, we have cases going this way and that way, and then there comes a stage when there is a meeting of the minds, as it were, as to what is likely to be okay and what isn't. I've no doubt that the dissenting judgments of Lord Sales, with whom Lord Hodge agreed, were designed to try to give, if you like, a sharper edge to how these decisions were to be made. Essentially, the argument was, look, if the police were entitled to get in here to free up this road, that must be on the basis that the protest having been there was now appropriately to be moved on, or at least that was the issue that had to be decided. Was it then appropriate for them to cause the matter to move on? And if that was right, then for Lord Sales and Lord Hodge, I think that would be more or less end of story. And I don't rule out the possibility that that debate is over. I could easily see a different composition of the Supreme Court coming to that view, and if they did, I think that the proportionality analysis might be put somewhat differently. Whether the European Court will stand over that, particularly if it means that there's no fresh assessment of the decision to prosecute, on the authorities, I would have thought is doubtful. But the European Court, as we know, is a political court, and therefore it doesn't necessarily mean that they wouldn't see the difficulty of any other approach.
Thank you.
Thanks very much. Do we have any other questions? Is there a third question out there for Sir Declan? Anybody like to come in? Oh, yep, we have a hand up there. Bryce, if you'd like to come in.
Thanks, Cheryl. Thanks very much, Sir Declan. Excellent talk and very interesting. Just picking up on the very last comment you made there about the European Court being a court. I wonder, would you like to expand upon what you really mean by that?
How long have we got, Bryce? I know what I mean, all right, but I'm not sure how far I should go with the description of it. But let me approach this in a I'm tempted to use an example which is more related to legacy than to this issue, and I don't know really whether I should. But the European Court does not close its eyes to the practicalities of what happens, and I think you can see that in some of its decisions within legacy issues concerning, for instance, Croatia. And that it is able to step back and take a view as to how principles are to be applied given the underlying scenario within which they have to be faced. Now, there's no doubt that there is an increasing tendency to public campaigning through exercise of the rights to freedom of expression, but also freedom of assembly. And that it's definitely causing problems for governments, and particularly for the Tory party, where the exercise of this kind of protest goes down very badly with their electorate. And I think it is likely, therefore, that there will be some attempt to introduce some kind of legislative fix to see if something can be achieved. And I think the European Court will not necessarily shy away from at least looking at an approach to proportionality that didn't involve an absolutely rigorous assessment of the proportionality issue in relation to each of the steps of arrest, removal, prosecution, conviction, sentencing. And that it could be persuaded that a slightly more modified approach could be adopted. I think that's what I'm thinking about. I think they've done it in other territories. I think we've all seen, that they're very conscious of making sure that convention rights are practical and effective rather than theoretical and illusory. And a system which is so fact-specific that it actually prevents the sensible operation of straightforward or sensible laws, I think is something which they would look at pretty closely.
Chris, do you want to come in on that? I see you've got a hand up.
Thanks. I was really just in response to your response to Bryce. I mean, it's an interesting definition of political court, which I think was emphasizing that the court was taking into account the consequences of its decisions. and I understand that. Do you consider that the Court of Appeal, the Northern Ireland Court of Appeal, when you were Chief Justice, was a political court?
No, we would never reach into those dizzy heights, Chris. We tried to apply the law as it was, but I mean, one of the things that I'm on record as, well, I think I'm on record as indicating that one of the decisions that we gave during my time was the decision on whether the prohibition of same-sex marriage was unlawful in breach of Article 8 Convention rights. Now, we made that decision. It arose during a period when there was no assembly in place, and that, I think, created its own an issue for us as to whether, if there was no assembly, and if there was, had been an assembly vote which was broadly in favour, albeit that the petition of concern had been lodged. I mean, we had to make a decision as to whether or not the absence of the ability to democratically deal with this matter through the allocated assembly meant that there was a different onus on the court to how it should approach the issue. And it's not clear to me, and I haven't a firm view about this, it's not clear to me that if the assembly had been there, that we would necessarily have made the same decision. And I also have to say that looking at the trend of the Supreme Court recently, it's not clear to me that the Supreme Court would have been as enthusiastic. Present Supreme Court would have been as enthusiastic as maybe the previous Supreme Court would have been. But I mean, who am I to get into those dizzy heights? I prefer to keep my feet on the ground, Chris.
Thank you, Sir Declan.
Bryce, do you want to come back in on that? Your hand has disappeared, Bryce.
All right, can you hear me now?
Yep, got you now.
I was wondering again if Sir Declan would like to expand upon that very last comment, the shift in the Supreme Court. I mean, are you suggesting the makeup of the Supreme Court now is, if you like, a more conservative one than in recent times, especially under the current president?
I think that there are a couple of decisions which issued in early July. SC and 8 others was one of them, which I then applied in a decision that I gave the following month. And there's a mantra now that the court is there to make decisions on the basis of the applicability of legal standards. And I think that terminology can hide an awful lot and give scope for withdrawing from territory that the Supreme Court certainly was perfectly happy to engage in prior to the departure of Baroness Hale and Lord Kerr. And it reached its epitome, I think, in the Northern Ireland human rights case with the decision on abortion services. But I mean, there's nothing unusual about the fact that the approach of a court changes as time goes on. I mean, if you look at the Irish Supreme Court, for instance, in the 60s and early 70s, the court involving Brian Walsh and others looked across the Atlantic to its American colleagues and became quite involved in finding the spaces that the Constitution hadn't actually dealt with and deciding that they were going to insert them. In America itself, you see, the Warren Court of the 60s, and then the more conservative courts that came thereafter. It's interesting to see. I mean, some would say that John Roberts, for instance, in the United States, is kind of trying to keep his court away from politics by finding ways of lending some support to some of its more liberal wing. The House of Lords itself went through periods of being very conservative, and then I mean, when Lord Bingham came in, he brought it along a certain distance, and David Newberger and Baroness Hale brought it along another way, and I think it's probably has rolled back a bit from it's certainly not progressing further along that track, and I think it's probably the reins have been put on a bit, and one can't ignore the fact that the president, deputy president of the court, for instance, in the abortion case, if I recollect correctly, were both dissenters, and they were dissenters because basically they felt this was a political issue and not one to be judged by legal standards. So I think that's where we are, but there's nothing unusual about it. I have absolutely no idea what's going to happen to the court that I used to chair. I'm afraid you're going to have to take that up with the Lady Chief Justice. No doubt she will decline to give you an answer, I suspect. But I like to think that we tried to take a pragmatic approach. But I mean, I think some of the decisions that we made, for instance, our decision on abortion, indicated that we were probably somewhat more conservative than the Supreme Court of the time. I'm not sure that approach would necessarily make us more conservative at the Supreme Court now.
Thank you very much. We have scope for one last question, and we do have a question here from Anurag Deb in the chat bar. So Anurag is one of our PhD students here in the School of Law and is also practiced. Can you see that? Can everybody see that in the chat bar?
Yeah. I'm just trying to scroll down here. Yeah, hold on, I've got it. Yeah.
It's quite long.
Okay. I'm not sure that I'm enthusiastic about the proposition that the European Court is happy to allow domestic courts to decide how anxious their scrutiny is going to be of executive action. I mean, I think that in the sort of territory that we're talking about here, where the rights at issue are freedom of expression and freedom of assembly, they are rights that are, although they're qualified, they are given a place of some importance in the firmament of the convention. And it seems to me that the thrust of the cases at the moment emphasizes the need for the individual assessment that I've talked about to Chris, and which Chris has raised. And I would have a question whether or not the court will be easily persuaded to move from that, but I'm not ruling out the possibility that politically it may choose to do so in this particular area. But I wouldn't be inclined to accept generally the proposition that the courts of the United Kingdom are the determinants of how anxious the scrutiny of executive action should be. I don't think I would accept that proposition. And I certainly think that the courts of the United Kingdom are required to pay close attention to the European jurisprudence. And if they don't, the European Court will put them right.
That seems like a fitting point to draw time on today's seminar. We are at 2 o'clock. So first of all, I would like to thank everyone for their attendance and participation today and for the excellent questions. most importantly, I would like to thank Sir Declan for so generously giving up his time to join us and for such a fascinating speech. So thank you very much, Sir Declan, and I hope to see you again soon. Thank you.
Okay. Thank you, Cheryl. I hope they release me from lockdown soon anyway, and I can get back out again. Thank you.
Again.
Bye.
Bye. Bye.